All right, let's go on the record on cause number DC211350, Flacco v. I don't know how to say that, Roshko
Yes, sir.
Construction, Inc. Council, make your appearances if you want to correct the pronunciation of that name.
Your Honor, Rob Crane, Billy McGill, and Sarah Rogers on behalf of the plaintiffs.
Jerry Ewing for defendant Roscoe Construction.
Jack Connor for defendants Pacheco Koch Consulting Engineers, Inc. and Pacheco Koch LLC.
Jill Chance on behalf of Rushco Construction.
Okay, let's go ahead and proceed.
I'm sorry, on the Jerry's iPad, I'm not gonna be able to remember your name, so can you give it to me again so I can write it down?
Yes, ma'am. Jerry Ewing, E-W-I-N-G.
Okay, thank you.
Thank you.
Judge Hoffman, we've got actually companion motions. Both defendants have filed motions to transfer venue, and both defendants have filed motions for leave to designate a responsible third party. And Jerry, did you want me to go forward with the venue argument?
Yes, sir.
Your Honor, if I may proceed.
You may.
Judge, I represent defendants Pacheco Koch Consulting Engineers, Inc. and Pacheco Koch LLC. I'll just refer to them as Pacheco Koch for purposes of argument today. We have before the court a motion to transfer venue. Briefly, Your Honor, the facts of the case are my client designed a bicycle hiking trail for the city of Plano. It's known as Legacy Trail. Roshko Construction built the trail. The trail was turned over to the city and allowed the public to start using it. Mr. Fiacco was riding his bicycle on the trail on October 8th, 2020. And when he ran off the trail and landed on some rocks, which are referred to as riprap, that were installed for erosion control underneath a bridge that passed over the trail. He was injured and filed this lawsuit. We are asking the court to transfer venue to Collin County pursuant to section 15.002 of the Texas Civil Practices and Remedies Code, because based on the plaintiff's pleadings, Collin County is the county where the condition exists. It's where the county where the accident occurred. It's the county where plaintiffs reside. It's the county where Roshko Construction is headquartered. And pursuant to the terms of my client's contract with the city of Plano, there's a form selection clause or venue selection clause that requires any lawsuit involving us to be in Collin County. And as you know, we've got this motion to designate. We anticipate.
Surely you're not saying that the plaintiff is bound by that contract. They're not a
The
party to
plaintiff
that
is not bound
contract.
by that contract, Judge. I'm not saying that. I'm just saying ultimately, because we anticipate the city of Plano may be involved in this, we would be bound by a mandatory venue clause for the county, possibly for the city, for Collin County. For those reasons, Judge, we respectfully ask this court to transfer venue to Collin County.
Mr. Ewan, did you want to add anything?
Judge, I think that's well said. My client obviously is in Collin County. You're going to hear our motion to designate responsible third party. In this case, the city frankly should be a party to this case. And under those circumstances, venue would be mandatory in Collin County. Just from a pure convenience standpoint, certainly Collin County is best for all. The only connection to Dallas County is the fact that Pacheco Koch is located there.
You're not trying to argue now that mandatory venue exists in Collin County, are you?
No, sir, Judge. The city is not currently a party.
All right, Mr. Crane.
Mr. McGill will go forward for us. Your Honor, I may pipe in on some factual matters, but he'll handle the legalities.
Okay. You're muted, Mr. McGill.
Can you hear me now?
Yes.
Okay. As you know, Texas law generally allows plaintiffs to choose venue unless there's a mandatory venue. And as the defendants have admitted, there's not a mandatory venue provision that's applicable. We've sued 15.02 of the venue statute says you can sue where the incident occurred, or you can sue if it's not a defendant who's not a person, you can sue in that defendant's county of residence. And in this case, we have elected, as we are allowed to do, to sue in Pacheco Cove's county of residence, which they admit is Dallas County. And there's nothing in the motion that they filed that contradicts this. As you've said that, and as the defendant submitted, the plaintiffs are not a party to this contract. And under Texas law, the Texas Supreme Court Pinto Technology case, the form selection clause can't be enforced against persons who are not parties to the contract containing the clause. So there's no basis for using the clause to transfer this case to Collin County. And as far as convenience and so forth, what the rule actually says, 15.002B, for convenience of the parties, the court may transfer where the court finds. And there's three different things the court must find. I'm going to focus on the first one, which all three of these have to be proved, but I think this is the one they're trying to seek venue transfer under. The court would have to find that maintenance in the county of suit would work an injustice to the movement, considering the movement's economic and personal hardship. Your Honor, this is not a case where we have one county in the Texas Panhandle and one county in South Texas. This is Dallas and Collin County. It may be inconvenient, may not be much fun to drive from McKinney to Dallas County, but this is not a situation where we're talking about working a hardship on Pacheco Co. or Roscoe. Mere inconvenience is not enough, and that's at most, that's what we have. So we don't believe there is any basis to transfer this case to Collin County.
Where are all the attorneys located? Mr. Crane, I think you're in Dallas. Mr. Ewing, you're in Dallas County, aren't you?
True. Yes, sir.
Mr. Connor, are you Dallas County?
I am in Dallas, Judge.
Ms. Chance, are you in Dallas County?
Yes, Your Honor.
So all the attorneys are in Dallas County.
Yes.
Okay. Yeah, I'm going to deny the motion to transfer. Let's go to the second motion.
Judge, I'll start on that motion. Mr. Connor has a companion motion, and we filed a motion to designate the city of Plano as a responsible third party. In this case, Judge, the plaintiffs, I know the court's very familiar with the Chapter 33 motion to designate responsible third party statute. So I'm not going to go into that wherewithal, Judge, but we'll discuss the pleadings that are asserted against the two defendants are these. Basically, that the defendants allowed construction of an unsafe bike path, that they revised or were a part of revising the design from the original design to an unsafe, defective bike path, that they failed to properly train their employees regarding the proper manner in which to select the materials to construct the legacy trail, and they were involved in selecting or approving unsafe materials for the construction and installation of legacy trail and its surrounding landscape. Truth be told, Judge, the city of Plano was directly involved in every aspect of that. In fact, they're the ones that directed certainly my client in what materials to use, where to place them. This construction was complete. It had been turned over to the city of Plano. The city of Plano is the owner, the operator, they control this bike trail. It's been open for some time. It's open today. It's exactly the same. It's been over a year since this accident occurred. There's a question of whether my client even has a duty under these circumstances since it had been turned over to the city and was completely within their control. But certainly the city was involved in deciding what size the riprap was going to be, whether to use the riprap as erosion control or not. And that is the complaint of the plaintiff, that riprap was used. Thus, the city should be named as responsible third party. All we have to do is meet notice requirements pursuant to pleadings, as you know, Judge, under the statute, and we have done that. Notably, the plaintiff did himself put the city of Plano on notice as required by the law. In that notice that he signed indicated that riprap should not have been used. That decision, if you look at exhibits to our motion, was made by the city of Plano. They wanted to use riprap for erosion control under the bridge where this bike path passes. And that is the basis for our motion, Judge.
Your Honor, I'm gonna let Rob Crane talk about this choosing the riprap issue. I think he's more up to speed on what all the facts are on that. I'm gonna have him address that, and then I may close off the argument on this.
Yeah, Your Honor, and this is probably a good preview real quick. There's been discovery on disclosures have been produced, including a number of emails. Unfortunately, a very pivotal email has not been produced by Pacheco Coke. City of Plano's outside counsel has called us, has read to us an email that describes that Pacheco Coke is the one who selected the riprap at issue here. You've heard Mr. Ewing say, no, it was just the City of Plano who chose the riprap. That is not true. And Mr. Ewing is not have the benefit yet of this email because Pacheco Coke, for some reason, we have not been produced this pivotal email that does exist. And you're going to hear more about this later. So I wanted to correct the facts that the City of Plano is the one who
do you have the email or not?
I do not have it physically. I've had it read to me by the outside counsel for the City of Plano, and I know exactly what it says. So the City of Plano did not choose for riprap to be used in this location. Pacheco Coke did so. So just factually, we don't have that information out yet, but as the court knows, right now we're at an RTP stage where we have objected to the RTP of the City of Plano. This is really a special exception type stage. Should we choose to file a motion to strike later, that would be the proper timing. And our objection to both of their motions to name the City of Plano as a responsible third party is that they have not properly pled. They've not specifically pled as to duty here. And Mr. McGill, I'll hand that back over to you, but I did want to clarify the factual statements because unfortunately Pacheco Coke has not produced what they should have produced in this email with the City of Plano, and therefore they're working under false information here.
Your Honor, if I may weigh in.
Sure.
If I may weigh in, I got skipped over a little bit.
Okay, go ahead.
Because we also have a motion for leave to designate, and with our motion, we filed with the court 3 exhibits. The first being the notice that Mr. Fiacco sent to the City of Plano, where he signed his notice specifically saying the City of Plano was responsible. As you know, Section 33.1004 says we just need to plead sufficient facts to show responsibility of the responsible third party we're trying to bring in. But in addition to the notice that Mr. Fiacco filed against the city, blaming them, I've attached 2 emails. The email that Mr. Crane's speaking about does not exist. This is the email that he's talking about. And I think the city attorney has misread an email to him. If you look at Exhibit B and Exhibit C attached to our reply to the plaintiff's response.
Can you go ahead
Judge,
and go ahead and share screen that?
Exhibit C came in last night. I'll pull up. See if I can pull up Exhibit C for you. All right, can you see this, Judge?
Not very well, but
Let me see if I can. Better?
it's okay. Go ahead.
All right, you see this. This is the first page of Exhibit C. It's from Lance Knox, who is with the city of Plano, to Brian at Roscoe, telling Brian, use the 12 by 18 stone option. So there the city is selecting the size of stones to use for the riprap. This is from Brian to Lance at the city, giving him the options that are available. Exhibit B is, I think we still go down. I don't know if they're, yeah, where they talk about, this is from a structural engineer giving information to Pacheco Coke about the common sizes of stones to be used. And then the email attachments are the text dot specifications for installing riprap. And we've attached the two emails that are in question, Exhibit B and Exhibit C, to our reply. There is whatever the attorney, I don't know what the attorney for the city of Plano told Mr. Crane. I wasn't part of that conversation. These are the emails. These have been produced. These are Bates labeled and have been produced. So if there's something out there that's different, I am not aware of it. This is what my client has provided me. And this is the conversation that is being spoken of, where the selection of riprap was made by the city and the riprap was installed at the city's request. So those are the two exhibits, those email selections, exhibits B and C to our reply. So, Your Honor, those are the facts. And so I don't want this court to be misled about what the facts are on this case as to who did the direction for installing riprap and who made the selection of stones. It was the city of Plano.
Okay.
And so not only have we pled sufficient facts, we've given the court exhibits or evidence of the facts to support the designation of the city.
Okay.
And Judge Mack, if I may add one thing, I don't want there to be any suggestion that I've misrepresented anything to the court, because I have definitely not. And if you look at my Exhibit A to my motion, Judge, therein lies in Exhibit A, the instruction we received from the city to use this riprap. It is right here. Ms. Chance is bringing it up from my office. Lance Knox is with the city of Plano. This is Friday, May 22nd, 2020, wherein he indicates to us that we needed to use the rock riprap, as it's called. It's basically large rock in that area. After that time, you can take that down, Jill. After that time, over the next few months, there's some correspondence that's going back and forth involving Pacheco Coke and the city, where they ultimately decide on the size. But the ultimate decision was the city of Plano's to use the riprap and place it in that location. And again, as Mr. Connor reflected,
Okay.
This is just a motion to designate responsible party.
Right. That's what I was kind of trying to get in here, is that I think the proper way to do this is to grant the motion, and then if through discovery, it sounds like Mr. Crane, there's still some discovery issues that haven't been resolved under 33.004L, I think, you'd have an opportunity to possibly strike that designation at some time in the future if the discovery doesn't support these contentions. But at this point, I think it's appropriate to go ahead and grant it. So we'll go ahead and grant those. Anything else today?
I just want, and both Mr. Ewing, Mr. Connor, we've had long history, very ethical lawyers, and I just don't think they're aware, Jack and Jerry, May 26, 2020 email from Kendall Hansey and the city of Plano. Y'all need to go get that email because that's the one that shows that Pacheco Coke is the one who, after screwing up in the design drawings and trying to grow grass under a bridge, realized, yeah, they state that they should have caught that. Yes, is a good point. Sorry, should have caught that in the drawings. There's not really any plants that would grow well beneath the overpass. My recommendation would be to have riprap placed adjacent to the trail for the link that runs between the overpass, so forth. So you guys need to get from Pacheco Coke that May 26 email that shows Pacheco Coke made the redesign off their original drawings for riprap.
Sounds good, guys. Have you already submitted orders for me?
Judge, we filed one this morning.
Your Honor, we have not filed one. I can get one to you pretty shortly.
On the motion to transfer?
I
Do
don't
you
know
want
if
to, me to prepare on both denial of venue and on?
Did you submit one, Mr. Crane?
I don't believe we have. We'll do so today.
Okay, go ahead. When you submit the order on both these orders, go ahead and put at the beginning that this was heard at on February 11, 2022. So instead of on this day at the beginning, but it was heard on February 11, 2022. Make sure you share the order with opposing counsel, and let's try to get that to me by Monday.
Judge,
Today preferably, because these motions should be pretty easy, but definitely by Tuesday.
Your
Okay,
Honor,
Judge,
just to clarify, do you want 4 orders, one for each of the 4 motions, or do you want it combined?
Are there 4 motions or?
There are companion motions to transfer venue and companion motions to designate a responsible third party.
But why don't you actually do this? Just do 2 orders, one for both of the transfer venues, one for both of the designation responsible third parties, and just do omnibus orders, submit those to my coordinator, and it will try to get those signed, but get those to me before Tuesday.
Rob, you're going to do venue,
We will.
and Jerry, you're
Jackie?
going to do
Yeah,
designation.
we'll do
Thank
it. Judge, disregard our order that we've filed an hour ago. We'll revise it accordingly.
Okay. Thank you, guys. You guys be safe, okay?
Thank
Thank
you.
you for
Have
your
a good
time,
day.
Judge.
Bye.
Okay, I think our next hearing is a motion to continue. Is that correct?
That's correct, Your Honor. And a request for a preferential setting.
Yeah, that's not likely, but we'll talk about it. Okay, so this is on Tony. Let's go on the record on DC 213950 ARM Energy Management LLC versus Medallion Pipeline Company. Council, make your appearances.
Good morning, Your Honor. Kate Shee of Quinn Emanuel for the plaintiff, ARM Energy Management LLC.
Good morning, Your Honor. Tom Patterson. It's been about a year since we were in front of you last. I'm with Sussman Godfrey. I represent Medallion, the defendant. And I believe with me here today is Kevin Downs. Just in the event you should ask for something to be put up on the screen, Mr. Downs is my guy.
Okay. Sounds good. Let's go ahead and proceed.
It was about a year ago, Your Honor, when we were last in front of you on ARM's application for temporary restraining order and temporary injunction. It had to do with an issue. There was the parties had entered into a long-term oil transportation agreement and a dock agreement or terminal agreement. ARM had assigned those agreements to a third party, Glencore. Glencore was providing credit support for those agreements that was required in the contracts. When Glencore terminated the assignment with ARM, Medallion asked for additional credit support. ARM was not willing to provide that additional credit support. We told them if they didn't provide it, we would execute on some letters of credit that were posted. They responded by saying that they were terminating the agreements, and they filed suit asking you to enter a temporary injunction. We had a bunch of hearings last spring on this, Your Honor. At the end of the day, the court denied the application for a temporary injunction. Medallion executed on those letters of credit. We proceeded in the summer doing discovery, document discovery, and we filed a motion for partial summary judgment on the issues that were then before the court. ARM changed lawyers and they amended their petition to allege fraud and fraud in the inducement. When we saw that they had amended to add fraud and fraud in the inducement, we figured that in this bench trial, the court would not be particularly enamored with the idea of granting a summary judgment when it was going to have to hear most likely the entire case anyway. So we withdrew that motion for partial summary judgment. Since then, the parties have engaged in extensive party and third-party document discovery. We have finished our expert discovery in the case. We have been taking fact witness depositions, but we are set for a preferential setting on April 5th of this year, which would be just a few days more north of a year since the case was filed. It's clear that we can't get the case ready to try, to your honor, on April 5th.
Do you have I don't see that you have a preferential setting. You already have one?
Yes, sir. I think when my understanding, I don't have the order here handy, but our understanding was we had a preferential setting for April 5th, which it sounds like it might have been precious. But regardless, we're not going to, it's a bench trial. We figured it'd be a week to 2 week bench trial. And we understood that we had a preferential setting on it. But anyway, the parties have agreed that we would ask the court for a short continuance of the trial setting. And hopefully, if the court could set us for June, that would, all the schedules come together for June on both parties' side, provided that works for the court. And just given the complexity of the case, the time the case will take, the fact that a number of witnesses and lawyers and experts will come from out of town, we also asked the court, in addition to continuing the case to a setting in June, to give us a special setting, which is, I understand why we're having the hearing today.
I mean, if you want a special setting, it would probably, I don't have down that you were specially set on that date. We have another special setting on April 5th. So I'm not sure if there's an order on that we just missed, but I don't see that there's a special setting. Let me see.
I will look for that, and perhaps Ms. Shee has it handy, but I don't have it here at my fingertips.
Let me see.
Candidly, I didn't understand April to be a special setting. I thought it was just a trial setting, but I may have misunderstood.
Yeah, I don't see anything that says this. I see that you requested one. I don't see that we granted it.
Okay. My apologies, Your Honor. That's been the understanding we've been proceeding on. But in any event, we're not going to be ready for an April 5 trial setting, and we'd respectfully ask the court to continue the case. And if the court is inclined to give us a special setting.
Okay, response.
Your Honor, the plaintiff is aligned in requesting a brief continuance, having trial in June or as soon thereafter as possible. We are eager to get on with the case. We'd like to get it tried, but we are in agreement with the defendant that a brief continuance is agreeable.
I just can't, this case is too new for me to do a special setting on at this point. We're, a couple years backlogged. I could give you one probably. You could either keep that date. I could reset you to another date. Is this a situation where there's a jury waiver, or is it a situation where you guys have just agreed to be non-jury?
There's a jury waiver in the agreement, Your Honor.
Is that correct, Ms. Shee?
That is correct.
Okay. And so, I'm happy to continue the case. I don't see giving it a special setting before 2023. So I don't mind just resetting you, and then we'll see if you get reached. But if you're a 2021 case, we're typically trying 2018 and 2019s right now. So I just don't see us being able to try this year on a 2021 case, unfortunately. y'all want to keep the trial setting? You want to move it, or do you want to request a special setting in 2023?
My preference, Your Honor, may be a little unorthodox, but it would be to get a setting when it's kind of somewhat realistic that we could actually go. And then also ask the court, could we have a backup preference or special setting in 2020?
You don't get two trial settings.
Well, I figured it was worth a shot.
I just don't see any dates this year. I've been going through my docket pretty extensively lately. We've had, as you know, in Dallas County, we've been starting and stopping with jury trials. There is a possibility that the best shot you have of going is if there's a delay in jury trials again, then we try non-juries. But as long as we have jury trials, as long as we're in jury trials, I'm going to be trying jury trials. So I think if you want a realistic trial setting, what I would suggest is pick something in 2023, and then we can specially set you, and that would allow you to take preference over other cases. That would be, if it's more important for you to get a date that's likely to go, I would go in 2023. If you just want a resetting, I'll set you any time. I just don't think you get reached because your case
Your Honor,
is.
excuse me, I apologize.
Go ahead.
From the planner's perspective, we would like to go as soon as practicable. And it sounds like that date may be in 2023. If there's any chance of going in 2022, we'd like to do that. This case is a major overhang for my client. It's a significant amount of money. It's frankly, hamstringing them in some other business they'd like to do. And they're eager to get going with trial as soon as possible.
Your Honor, I heard what you said. It sounds like if there's not a realistic trial setting where we'll be reached in 2022, then I'm not enamored with this, but I think the most sensible thing to do would be to set us for as early in 2023 as is practicable.
Is that okay with you, or what do you prefer?
If there is a chance, if jury trials go on pause, that this could be tried in 2022, that would certainly be our preference, to at least be on the list to try to do that.
But
So
when is the next COVID surge going to be then?
it's going to be in November, Your Honor.
I mean, it's
going to be in November. We're entering a time period. The doctor on my name isn't for medical doctor. It's
exactly. I mean,
and it's a JD. But my assumption is we're going to go into a period now where we're going to be done sort of with COVID until things get cold again, and then we're going to have another surge of COVID next winter. And so we'll probably be having just bench trials again next winter if life continues.
Dr. Patterson, then we'll. I mean, I'm just giving you your options. Either you just pick a date. There are no realistic dates unless we have a COVID surge in 2022, but I can set you. I mean, I'm just trying to, I think you're asking for something that doesn't exist.
Yeah.
She is that you want a date this year that's realistic. There isn't one. So, but I can set you, and there's always a chance. I mean, you could pick any date this year, and there's a chance. There's a chance that, the moon may fall out of the orbit and hit the earth. And I mean, there's always a chance. I don't want to say there's not, but if you want a realistic chance of going, and I'm being a little facetious, it's not that unlikely, but there are no good dates this year. I mean, unfortunately, they're just not any. We're so backed up. I have 30 cases set most weeks. And so, and you guys go as a non-jury, you go behind all the jury cases. So if it's a jury week, you're probably not, especially on a 1 to 2 week non-jury. But that being said, if we have a COVID surge, then there's a possibility. Maybe it's next. I have no idea. There's some new variant out there in Denmark. It may spread. It may not spread. I don't know. I mean, it's.
Your Honor, what if we do this? What if we agree to a date, a preferential date in as soon in 2023 as possible. And if a COVID surge hits, Ms. Shi and I contact Ms. Pinson and respectfully ask if we could be put to trial before Your Honor during that COVID surge. Would that work?
I mean, I can't make any guarantees, but yeah, I mean, if you guys want to do that, you can.
I don't see we have an option.
Let me look at one thing. There is one possibility, I guess. There is a non-jury week during the week of June 5th. I didn't realize we still had that. Let me double check the date here. Let's see, I'm sorry, it's July 5th. I'm not going to be here. One other option possibly is that we could get you a visiting judge. You'd have to pay for a court reporter, but we could get you a visiting judge in the end of June. Again, at the end of June, you wouldn't need a court reporter because I'm not going to be here at the end of June. You would need to get it done within 2 weeks, but if you could agree on a visiting judge that you guys both agree on, and that visiting judge is available for 2 weeks, I don't mind setting you then, and you wouldn't have to pay a court reporter. Tony, I'm giving you work to do, unfortunately, but that's another option.
When would that be, Your Honor?
It would be if June. Let me see. The last week of June and the first week of July.
And how do you determine who the visiting, would we be able to agree on the visiting judge?
You would need to contact find a visiting judge, somebody who qualifies as a visiting judge.
Okay.
And then June 28th, the week of June 28th and July 5th.
I'm game for trying that. I need to talk to my client, and obviously Ms. Shi and I will need to communicate back and forth, but we're game to try to see if we
and let me make sure it's clear how this works, is that it has to be somebody who's qualified as a visiting judge for this judicial region. So I don't know where Ms. Shi is from, but let's say there's a judge in New Hampshire or a judge in Houston who you guys like. I have to be able to fund this out of the visiting judge funds for this judicial region. So it has to be on the list of judges who are, my court reporter. Okay, well, she's going to be on vacation. So, but we can work something out. We could, get a substitute court reporter if we needed to. But it has to be a visiting judge. So think of people who served in this judicial region, Collin County judges, Dallas County judges who are no longer judges. So people like Jim Jordan, Lorraine Raggio, King Pfeiffer, Marty Lowy, those types of folks. I've already talked to Jim Jordan about it. He's not available, unfortunately, because I was hoping he would cover me those 2 weeks. But that's an option. Do you guys want to talk to your clients? And do you know any of those folks that I just mentioned? Judge Wheelis, I know, is available, or who does. I know people who do this. Judge Murphy does it. Judge Stokes. Those are typically the judges that kind of do this kind of stuff.
So I have Judge Raggio, Lowy, Wheelis, Murphy, and Stokes. Are those?
Yeah, Jordan's not available those 2 weeks.
Okay. Well, I'm
trying to think if Judge Ginsburg's our tax court judge. I'm not sure he could do it. Tapscott, I don't think he can't do it because he doesn't qualify. He's working for Also, they can't be working for a law firm, so Tapscott couldn't do it. Who else am I missing? Kind of what comes to mind are those judges. There may be other judges, I just can't think of any. But if you like the idea and you want to make calls to those people, you're welcome to. I know that those folks, I'm pretty sure all those folks qualify. But and there may be some others as well. One other place you can kind of look to see what the list is go to the Dallas Bar Association judicial evaluation poll, and it will list all the I think it lists all the visiting judges that are in Dallas County. They're all rated there. So I think that would give you some other, those are the ones that kind of come to mind.
It would be hard to find someone we like as much as you, Your Honor. But we will do our best.
But we
What do you-
appreciate,
And we very
So
much.
what do you guys want to kind of look at that idea, and if that doesn't work, then come back, or what do you want to do at this point?
I think that sounds right. Like Mr. Patterson, I need to speak with my client, but I do appreciate the court suggesting a way to get this tried soon. It means a lot. Thank you.
Yeah, we're just trying to
Right.
figure things out. So
Your Honor, I guess there's one question, which will help, I think, with both of our clients. If we don't get this done in June, when is the earliest in 2023 that you could set us for a preferential or have a special setting?
let me see, probably, pretty early, because we've been setting most things this year. So let me just double check. We could do any time, pretty much. So July 3rd. Let me just see. Sorry, not July 3rd. January 3rd. Anytime in January. Let me see. I'm just trying to see if we have any special settings next year. I think we have one, but I just don't remember what it is. Anytime in February.
That's good enough, Your Honor, for me.
Anytime in March. Anytime in April. Yeah, it's pretty much the only date, May 16th of next year, we can't do. So we're pretty open next year.
Perfect.
Would it be possible to take a preferential setting in January now, and we would release that if we could agree on a visiting judge?
I'd rather just get it resolved one way or the other. You're not gonna, there's plenty of dates. So I would suggest maybe let's reset this hearing for next Friday, give you time to kind of look into it. Feel free to talk to visiting judges, anybody on the visiting judge list that's in the Dallas Bar. And if they're available those 2 weeks and willing to do it, then, you both have to agree on them. If you're not both going to agree, I'm not doing this. So, and then we can figure that out.
Right.
So let's meet again next Friday at 9:30 and we'll figure it out.
Thank you, Your Honor.
Thank
Does that
you, Your
work
Honor.
for you, Michelle?
Absolutely. Thank you.
Thank you, guys.
Appreciate it, Your Honor.
We'll see. Rhonda, go ahead and reset this for next Friday at 9:30 and we'll go from there.
Thank you, sir.
Thank you. Okay. Our next hearing, I believe, is (9:30) Hunter Allen versus Eland Energy. Is everyone here on that case?
Yes, Your Honor. Your Honor.
Okay. Tony, let's go on the record on cause number DC 2200743, Allen v. Eland Energy Council make your appearances.
Good morning, Your Honor. This is Ben Barnes, and I'm here on behalf of the plaintiffs, Hunter and Carol Allen, in their capacity as co-trustees of the Allen 2018 Family Trust.
Good morning, Your Honor. It's Matt Stamlin here on behalf of the.
I couldn't hear you. You cut out.
Oh, I'm sorry, Your Honor. Good morning. Matt Stamel on behalf of the defendants.
Okay. Anyone else?
No, Your
Okay,
Honor.
let's proceed.
Your Honor, actually, may I just jump in real quick? We have two motions pending, and we filed a motion to abate, which I think just in due course probably makes more sense to hear before we hear the motion for expedited discovery, given what we're arguing. Our position is we shouldn't even reach this issue of expedited discovery, given a mandatory mediation provision in the documents that the clients executed. We have a mediation scheduled for next week. We have a mediator. We're set to mediate. Plaintiffs demanded mediation. We agreed. And subsequent to the demand for mediation, they filed their motion for expedited discovery. So we think it's proper that this case gets stayed or abated some period of time pending the mediation. And I'd ask that we consider that motion before we get into the motion for expedited discovery, notwithstanding the fact that they filed their motion prior to the motion to abate.
When is the mediation next week?
Yeah, it's scheduled for next Tuesday, Your Honor. Judge Martin.
Do we want to just go ahead and reset this to next Friday? And
That seems like it makes the most sense to me, Your Honor, because we're hopeful we can resolve the issues. Like this is a family dispute amongst family members about family-owned businesses that have been in the family for decades, and the parties back in 2007, when it was the two brothers, they agreed to mediate disputes, and we have the son of the deceased brother who's refusing to do that. So we would ask that we mediate, and if we can't get it resolved, we can come back down and start talking about expedited discovery.
Judge, if I could just interject, I disagree. I would request that the court hear both motions today. We fully briefed the motion for expedited discovery. The defendants have asked to abate this case for 4 days based on an agreement that none of the parties to this case actually signed, and that explicitly does not apply to this dispute. And respectfully, Judge, we're here, we briefed the case, we're prepared. I'd ask that you consider both motions this morning.
Mr. Stammel, was this agreement signed?
It sure was, Your Honor. I mean, it's very clever how they're trying to argue this, but if I could, I will quote the provision.
To be clear, Judge, the parties to the agreement are completely distinct from the parties to this lawsuit.
Your Honor, this is the language. It says, it shall be a mandatory prerequisite that prior to any owner bringing any legal action or other legal proceeding against any jointly owned company in connection with ownership of a jointly owned company or the matters made the subject of this agreement, that the matters in dispute be first submitted to non-binding mediation. Owners are the plaintiffs in this case. They're the trusts that own the jointly owned company, which is the defendant. This is exactly the situation that this contemplated. So just to back it up, just a hair, this agreement was entered into in 2007 between two brothers and their wives. My client is Greg. The other brother is Tim. Tim's wife is Carol, who's one of the trustees of the trust as the plaintiff. They entered into this agreement in 2007 when Tim became ill, and they agreed that Greg, when and if Tim passed, Greg, my client, would manage the jointly owned properties that Greg and Tim have been amassing since 1984. Raw land, ownership interest in business. Tim and Greg decided that yes, Greg would go ahead and manage these assets, but they also agreed that there would be mediation if there was a dispute, just like we have now. We have a dispute now. The trusts who own the defendants, it's all in the paper. The trust owns 50% of the defendants. They have a dispute with us. They have a problem with us. They've alleged some things, so we have to mediate. And that's exactly what this provision says in section 7.1. a mandatory prerequisite that prior to any owner, and it can't be disputed that the trusts are owners, before they can file suit against a jointly owned company like E Holdings and Elan Energy, they have to mediate.
Judge, if I could share my screen, please.
Sure. It's not sharing, whatever you're doing. I mean, it's sharing a blank screen. There we go. Okay, well, that's the motion.
Judge, I'd like to introduce you to the parties to this case, because with all due respect to Mr. Stammel, I think he's conflating a lot of issues. So the parties to this case, as I mentioned, are the Allen 2018 Family Trust. The Allen 2018 Family Trust, that's a 50% owner of E Holdings Limited Partnership, one of the defendants, and the other defendant is Elan Energy. The claims in this case involve only the Allen 2018 Family Trust, E Holdings, and Elan Energy. The agreement that Mr. Stammel is describing is an agreement between Tim Allen, Carol Allen on one side, and Greg Allen and his wife on the other side. The agreement has no bearing here because none of the parties to this case are signatories to that agreement. Whatever Greg and Tim agreed to isn't pertinent to what's going on here. And the other thing that's important, Judge, is that the E Holding Limited Partnership Agreement, you see that Greg Allen and the Allen 2018 Family Trust are partners in the E Holding Limited Partnership. That partnership agreement was recently amended, and it was signed, the current version was signed, I think on December 31st, 2021. And it includes an integration clause that specifically says that this agreement, including exhibits hereto, constitutes the entire agreement among the parties pertaining to the subject matter hereof. Now, this dispute only involves E Holdings and Elan Energy. The signatories to the E Holding Limited Partnership Agreement are the Allen 2018 Family Trust and Elan Energy and Greg Allen, okay? And the E Holding Limited Partnership Agreement also addresses dispute resolution. It says that in section 10.11, in addition to the rights and remedies provided herein in this agreement, the parties hereto, which include the parties I just listed, shall be entitled to whatever other legal or equitable remedies are otherwise available to them. Judge, even if this agreement that Mr. Stammel's referring to applied to these parties in this case, which it doesn't, but even if it did, that mediation requirement was superseded through this E Holding Limited Partnership Agreement. But ultimately, Judge, I think it's a moot point because the mediation is next Tuesday. They're asking for a stay of 4 days. And as I mentioned earlier, we briefed the issues, we're prepared for the hearing, and I'd like to present my argument to the court. And if you're inclined to defer ruling until after the mediation, I think that's fine. But
So what we're going to do is just I'm not abating the case. I'm just going to reset it to this hearing to next Friday. And then at that point, maybe you've partially settled the case. Maybe there's a lot of things can happen in the mediation. So we're just going to reset this hearing to next Friday. Does 10 o'clock sound okay to you guys?
That works for us, Your Honor. Thank you.
excuse me, Your Honor, I'm just checking my calendar. Yes, that works for me, Judge.
Okay, all right, so Rhonda, go ahead and reset this to next Friday at 10 o'clock. All right, guys, and if the case settles in mediation, obviously let us know so we can cancel the hearing.
Will do. Thank you, Your Honor.
Thank you, Judge.
All right, thank you, guys. Okay. There's a Matt oh, nope. Okay. All right, we'll go off of